You're live, Charlotte.
Okay, good morning. This is the Subcommittee on Family and Juvenile Law meeting this morning, which is March the 13th. We have a couple of bills that we really need to discuss a little bit further. And I wanted to start out with those bills if we could. I don't think I see Delegate Bartlett, but Lauren, are you able to go over the amendments to HB 267, or would you prefer to just wait?
I'm here, Madam Chair.
Oh, there she is. Wonderful, wonderful, wonderful. Okay, thank you very much, Delegate Bartlett. Would you please go over your amendments?
Yes. Okay, so starting with amendment number 1, it strikes the requirement to give notice of intent to travel and adds language to establish the requirements for petition under the bill and provides the court with risk factors and requirements for prevention order and authorizes the court to issue a warrant for physical custody of a child. The other changes are technical, which are removing section 9-106 and 9.7-108 from the bill and adding section 9.7-111.
Okay, so should we go? I think we should go through them one at a time. I think,
Sure.
How many amendments are there total?
There are a total of 4, I believe.
Okay, let's do that. And do we need to put them on the screen? Because there should be a
Well, it looks like Jeremiah just put up an interlineated version. If
That's
you want
what
to
I have. So let me
Yeah.
I'll pull it back up.
okay.
There you go.
Yeah, and also Delegate Kaufman is having difficulty getting in. If we could resend the link to him.
Okay.
Okay. All right. Let's see. So we got amendment number 1, which is going to be this first section, right?
Right. And so we changed the title because the notice of intent to travel is completely gone. So we took all of that out because it really didn't make any sense. But anyway, we're taking out the notice of intent to travel, and we're just putting in that, and we're taking out everything relating to that.
Okay.
Okay.
All right. So what does amendment number 1 do for us again? My apologies.
Okay, no problem. So it strikes the notice of intent to travel, and it adds language establishing the requirements for petition under the bill and provides the court with risk factors, requirements for a prevention order, and authorizes the court to issue a warrant for physical custody. Then we strike sections 9-106 because that is already existing law and it doesn't need to be here because it's just not necessary. And 9.7-108 from the bill. And we add section 9.7-111.
Okay. All right. Committee, are there any questions regarding this First Amendment? Does everybody understand what this does now? Because we're changing the bill quite a bit now, correct? It's no longer with the notice of intent, but it's the actual, I think, establishment of those requirements. And I have the, let's see, I think I have a copy of the amendments that are sort of documented in the way that Delegate Bartlett is stating. Does anybody have a question about amendment number 1? Okay, I don't see any questions. Go ahead, Delegate Bartlett, with amendment number 2.
Okay, amendment number 2. Hold on, I just got a message from Delegate Kaufman. I think he needs the link.
Yeah, I just sent it to him.
Okay, all right. Amendment number 2, if you want to go back
Yes.
to it. Mhm.
Okay, whenever you're ready.
I'm ready. I didn't know if you wanted to put up the interlineated copy again.
Yeah,
Is it helpful?
is it? Yeah, I'm sure it's helpful to everybody.
Okay, amendment number 2.
And it
Strikes,
starts on page 2.
starts on page 2. And it's striking the entire 9-106, as I mentioned earlier, because it's already in Maryland law and it doesn't need to be referenced here. It was just kind of confusing leaving it in. So you can just keep strolling down to the beginning of page 3 or towards the middle of page 3. Okay, here we go. So we also have some technical amendments to fix the definitions. So abduction, and we're also adding, we're adding that abduction means the wrongful removal or wrongful retention of a child. The taking and keeping comes in later under, and you'll see in just a minute how we defined it. So abduction is the overarching wrongful removal or wrongful retention of a child. So that's amendment, and we strike the taking and keeping.
Okay.
And it might make sense if we continue on down into the definitions. Because here right where it says record. So here we're explaining record. We're stating that record does not include record and travel document, but it does not include a passport or visa. Then we go and define wrongful removal means the taking, and then wrongful retention means the keeping, which is what we just clarified that and made it a little clearer.
Okay, and that's at the bottom of the page.
Yes, at the bottom of the
Wrongful
page.
removal. Okay.
And so that is all
Let's see.
of amendment number 2.
Okay. Okay, does anybody have questions regarding amendment number 2?
Oh, and also one more thing I forgot to mention, that we struck lines 25 through 29 on page 3.
Okay.
This is very brief. I
So-
just want to say Delegate Kaufman is here. Sorry for the snafu.
No, it's okay. So go back up to page 2 to lines 5 through 32. So that's what was struck. Okay, page 2. Okay,
Yes.
so that's the beginning.
Right, and so that's
then-
all, that
Mhm.
is all of 9-106,
Okay,
which is already existing law.
gotcha. Okay, now go to page 3.
The line 24.
Mhm.
And here is where we are redefining abduction to mean the wrongful removal or wrongful retention of a child. And we're deleting taking and keeping because each one of those applies to wrongful removal and wrongful retention respectively.
Okay, and then go down to the bottom of page 3. Okay. All right. Keep going, I think. Is it
Yes, to the top of page
page
4.
4? Yeah. Okay. All right. Does anybody have any questions? Okay, I don't see any. All right, if you will go ahead with amendment 3.
Okay, same page where we just were,
Mhm. So back to page
at the top
4.
of page 4. Okay, line 6, where it says record, we define record. And we also define travel document. And we distinguish what is not included in the definition, meaning passport and visa. But we bring in wrongful removal, and that's the taking of a child, and then wrongful detention, which is the keeping.
Okay. And why was passport taken out, or visa, or travel document?
Because it doesn't necessarily apply, because the one's travel document could be used for other purposes, passport and visa. It didn't necessarily apply here. We were talking about mostly the tickets, the reservation, the itinerary, things of that sort. The passport itself doesn't necessarily indicate travel.
Gotcha. Okay. Because we're talking about imminent travel.
Yes, exactly.
Okay.
Okay, and then on, so when we get to line 20 on that same page.
If you can move us down to line 20. Yeah, perfect. Thank you.
Okay, we, hold on, actually, it's not on that page. Keep going, I'm sorry. We're gonna insert on, keep going. I wanna get us to 9 point. Okay, I'm sorry, Jeremiah. Go back up to page 4. Okay, we're on page 4. That's where we are. Okay, all right. And so we are on page 4. We are adding sections 9.5-109. When if you go down a little bit, you'll see it. It says after line 20 is what we have in the. There we go. So section, that's what we're adding, where it says 9.7 at line 29.7-103. We're explaining that these sections apply to cooperation and communication among courts in a proceeding under this title. That language is literally, it's going to incorporate, you'll see shortly, it's going to incorporate 109 and 111 into the bill.
Okay.
Where we authorize you'll see where we authorize the warrants. Okay, we can go on down to line 27, and we're inserting this information where it authorizes a prosecutor or public authority to seek a warrant for physical custody or other prevention measures. This is important because, again, we're talking imminent. This would allow a prosecutor or public authority to, they could be at the airport, they could stop the abduction, and that's very important. And then we just fix the numbering based on the amended language.
Okay. All right. Are there any questions about Amendment 3 and what we're doing here or trying to accomplish? All right, Delegate Simpson, you have a question?
The only question I have is looking at page 6. I think it's line 14F.
Where on 6?
It's
Line 4.
14F. Okay, so Did you, so we took out, you took out the part where they're saying that they have to provide all that information to the non-traveling parent?
Right,
Yeah.
but we actually haven't gotten to that
Okay,
amendment
I'm sorry
section.
then.
Wait, I apologize. Yes, we hadn't gotten that far yet. We're
All right.
about to get there.
Good, I'm glad to see. Because I
That's
think I'm
amendment
looking,
4.
yeah, I think I'm looking at the wrong document. That's the only real big issue I had. I don't have a problem if they provide it to the court. I just had an issue if they were providing it to the non-traveling parent. It just seemed very, for somebody that I'm divorced from, I didn't want to give them my financial statement and everything.
Right, that's amendment number 4, and we were just getting ready to go to
Yeah, we'll
4.
go into that. Any questions about amendment number 3?
No,
Okay.
very
No,
good,
it's okay. We'll come back to you on amendment number 4.
very
okay.
thorough.
Okay. Anybody else have any questions about amendment 3? Okay. And let's go ahead and proceed with amendment 4.
Okay,
You do have another person with a question.
Oh, sorry. Okay. I can't see. Let me
You
see.
got to unmute himself. Delegate Valentine.
Yes,
Is that
Oh,
valid?
You
Okay.
have your
Okay.
hand up.
thank you, Madam Chair. Could you give me an example of what a public authority is? That's terminology I'm not familiar with. In the part where it says prosecutor or a public authority, like a definition of what that might be, who that might be.
is Lauren still here? I'm gonna
Yeah.
give my definition, but if Lauren could correct me if I'm incorrect.
Yes, I'm going to look up that section right now. It might be the Attorney General, but let me check.
Yeah.
Yes, that section 9.5-315 talks about a lawful action by the Attorney General. So I think that might be what they're referring to there. If this is, Delegate Bartlett can correct me on this, but I think this language is from the Uniform Child Abduction Prevention Act. I think that's what is being adopted here. So it's
That's
it's
correct.
using similar. It's trying to stay consistent with the other uniform act that's in family law section. Title 9, subtitle 5, which is the Uniform Child Custody Jurisdiction and Enforcement Act. So it's using the same terminology.
Okay, thank you. I just wasn't familiar with that terminology. Thank you.
Any other questions on amendment 3?
I did have one other question, if I may.
Okay. Okay, Delegate Simpson.
Did we take care of, I guess, the issue? I noticed it's like, it prevents if a parent really doesn't already have a passport. But what happens if they already do have a passport before?
Thank you.
Can someone mute themselves?
Yeah, it looks like it makes it, if you don't already have a passport, that there's stuff in place. But what if they already have one? Like this is a family already travel.
Travel document has nothing to do with passport or visa. We
Okay.
took that out because one could have a passport. That doesn't necessarily mean you're going anywhere. And so we're not defining that as travel document. The only definition of travel document that we included was your itinerary or your tickets or things of that sort, because then that shows that that you're planning to travel. Just having a passport or visa alone doesn't mean anything.
Right.
Okay. Any other questions on amendment 3? Okay. Delegate Bartlett, if you'll go ahead to amendment 4, please.
Thank you. Okay, so amendment 4 is the big one. This was the one I think that most people had concerns about. So we did a lot of striking here. So on page 5, we begin on page 5. Okay, so we at line 2 from has jurisdiction to make a child custody determination with respect to the child at issue under, and this is what Lauren was referring to, the UCCJEA, or the Uniform Child Custody Jurisdiction and Enforcement Act. Instead, we just, we're striking all of that. We're striking that language because we can just say at issue under 9.5 of this article. It just makes it tighter. And then we're adding language that says a court in this state shall have temporary emergency jurisdiction under 9.5-204, which is from the UCCJEA, if the court finds a credible risk of abduction of a child. Okay, I'll continue on. Okay, then 9.610-106 at section A, we state that the petition shall specify the risk factors for, and we took out this language about we took out the references here because we just say it's cleaner to say the petition shall specify the risk factors for abduction, including, and then we just referenced it back to 9.7-107 of this article, of this title, where we actually list the risk factors. It was just tighter language. So then we go down to, let's see where we are now. So B, we're just doing some renumbering here. And then we keep going.
So hold on for a second. Let's look at the risk factors. I just want to,
Well,
there's 6 of them.
Well, now we're just talking about what the petition needs to have.
Oh,
This
okay.
isn't the risk
They need to
factors.
contain.
This,
Okay.
yeah, we're just saying your name of birth, that type
Gotcha.
of stuff. That needs to
Okay.
be in the petition. But then
Okay.
we go down to 9.7-105. And we are taking out, now this is the strikeout stuff. So when we get here, we are taking out this mediated custody settlement. We're taking out all of that language, and we're adding language that is directly from the uniform language. So we're taking out all the business, and if you keep going down, we're moving all of this out of here, and we get straight to the risk factors. Now, these are the risk factors.
Got it.
Okay, and so we just get into, and these are reasonable things. You threaten to abduct the child, you've gauged the indications like you stop working, you sell your primary residence, you buy some tickets, those types of things. And, these are things that can be considered risk factors. You close your bank accounts. It looks like you're getting ready to leave. You apply for your passport or visa, or you start getting those travel documents we're talking about. Applying for the visa itself is not alone. These all go into they can all be used as a factor. And then you try to get the child's birth certificate from the school or their medical records, or you start, so those are some of the listed risk factors. And then we go into, on page 7.
So Delegate Bartlett, let's hold on for a second. Are there any questions up to this point? Because I know we're going to get into much more detail shortly. Are there any questions right now? Risk factors?
I have a question. Yeah.
Okay. All right. Go ahead.
All right. My question, Delegate Bartlett, is this. What was page 6 and 7 in the original? So all of that is gone?
Yes.
All right.
So,
and put in risk. Okay. Okay.
So that was under 9 point, I believe, let's see, where was that? We can go up some more.
It was.
That was under 9. What was the old
9.7
9.7-105?
105.
Right. So that is not in any way or any circumstance the uniform language. I believe when the bill came originally from a previous set of folks who were working on it, that language made sense at the time. But now that we have since had 4 years of having the uniform language in place, this language does not quite make sense. I've talked to the practitioners. It doesn't fit with the way it's convoluted. It's too jumbled. It's adding in pieces like a quilt almost that don't quite fit the way a child abduction proceeding should go forward.
Mhm.
Okay.
Because for instance, we even talk about divorced parents where one has held foreign citizenship prior to that's prejudicial, and it doesn't fit.
Okay, thank you.
And Delegate Taylor, did you have a question?
I did, and my apologies, I'm on 2 meetings at the same time. I wonder, are there any other amendments, or have we finished going through all the amendments?
No, there's more.
Okay, well, I'll hold my question till the end then. Thank you.
Okay, no problem. And I guess I have a really basic question, Delegate Bartlett. Are most of the states that are putting together similar legislation also pretty much basing their legislation on the federal unified, what is it? I can't even.
The uniform, yep, the Uniform Child Abduction Prevention Act. Yes.
Right. Okay.
Yes, and we did this, which is what Lauren was referring to. We did this previously when we changed the Uniform Child Jurisdiction. I forget what it said, Jurisdiction Enforcement Act. So we did this then when that was, went into practice with most states, and now we're doing it kind of again, where the actual abduction language has been adopted by different states.
Got it. Okay. Any other questions regarding this section with the factors? I know it's a lot. That's why I want to kind of slow it down just a little bit to make sure everybody gets it. Okay, Delegate Bartlett, if you'll continue.
Okay, so we also deleted section 9.7-106. Okay, so that's gone. And we start with 9.7-107, where we get into the risk factors. These are super helpful. It's my understanding these are super helpful for the court. These are super helpful for the practitioner. Everybody's on the same page, and it's cleaner than some of the risk factors that were kind of, like I said, kind of hodgepodge. Different instances were, kind of brought together, trying to take some particular fact patterns and create law, whereas this has already been vetted through the Uniform Law Commission, and it's understood and accepted language that makes it cleaner. That's essentially what we're doing. So as I mentioned, these are some of the risk factors, just leaving your job, terminating your lease, closing your bank account, trying to get birth certificates from the school, things that you normally, might not need to do. And none of these factors in isolation, would necessarily indicate abduction. But if you kind of start putting things together, it makes sense.
Okay.
Yeah. So
any questions about the risk factors? Anything else? Anybody have? Okay, we can keep going, Delegate.
Okay, and so then we look at section, okay, so we're 9.7. So we did page 7, line 4. Where are we now? I can't tell what page we're on.
Yeah.
We are on.
Okay, we're getting ready to start page 8, it looks like.
Yeah.
Okay, all right, page 8. We get into, hold on one second here. Okay, so this is just continuation of the risk factors. Because there are a lot, I mean, and this, like I said, this is it's helpful for the practitioners and it's helpful for the court. So we have a lot of risk factors that have been vetted. And then we made one small change that to fix a drafting issue. If we go to B under this section, and we just needed to fix it to say, instead of section, it should have said title under B. In a hearing on a petition under this, we just changed that to title, the court shall consider any evidence that the respondent believed. And we continued on, we just continue on. This is all new language for B. And just to go over a little bit what B does, it just simply states that that any evidence that if the respondent did something in, good faith, this is just, this is sort of like a good faith reasoning that you could present to the court. And if it's not necessarily to avoid, and they're doing it to avoid imminent harm to the child. We wanted to put that, you need to put something like that in there to make sure that you're helping someone who really is innocent or who is trying to protect the child. Okay, then we continue on to 9.7, 108. And this again is all new language, and it says that if the petition has these things in it, we list that it should have how the court has jurisdiction. These are things that you would normally put in a petition anyway, but you just list, we want to make sure that this language is included in the petition. Again, it makes it easier for the parties or the attorneys for the parties, as well as the court to go back to and see, to make sure that all these technical fixes are within the petition, because, as many people know, you can lose a case based on technicality. So at least this way, everybody's coming in with the same information, knowing what has to be in the petition, what is required to be in the petition. The petition is good, but if at the hearing on the petition, the court can also review the evidence, and if they may find on their own, so they can review, they can have the petition, or on the court's own motion, the court can review the evidence, and if they find credible risk of abduction, they can enter an abduction prevention order. Again, just putting everybody on the same page. We can keep continuing down for number 2. Yep, and so we just go into what the order needs to say, what the order needs to include, and the so it can include, the travel itinerary of the child, the physical address and telephone numbers where the child can be reached, copies of the travel documents, and the prohibition could include removing the child from the state. A prohibition on the respondent that cannot remove the child from the state, or remove or retain the child in violation of the custody, remove the child from school. So these are just, again, this is language that the court would utilize and put in their order. They could put in their order.
Okay. Any questions about the petition process and what needs to be in it? Okay. All right. I don't see anyone, so keep going, Delegate.
Okay. And now we're continuing on. Let me go down just a little bit more. Okay. So then keep going, please. So again, we go, still, this is language for the court to know that, okay, so this language is simply, again, laying it out for the court system, but it's also helpful. Another reason why this is so helpful, the uniform law language is so helpful, is because if we have to go through the State Department, now we also have everything that we needed, or you have to go through the embassy. It puts everybody on the same page as opposed to having some language in and some language not in. This way, if an embassy gets it, or if the State Department gets the order, they've seen it before, they understand it, they know what's going on, and they can, they can act accordingly if we need to have to try to return a child or anything of that nature. And then let's see, where else are we? So you can register it with the embassy. You can get if you need to get any type of privacy waiver for the child, that could be in there in the court order. Continuing on down, the court may impose some restrictions with respect to visitation, could require the respondent to pay court cost or cost of any supervision, and require the respondent to post bond, pay for education. These are those types of things that are actually pretty good. And then to Section E, it's Section E, yeah, right there. Thank you, Jeremiah. To prevent the imminent abduction, the court, and this is when we start getting back into the warrant. So the court could issue a warrant to take the child under, and then we reference back to we reference down to Section 9.7-109. And they could also call in for law enforcement to take any action reasonably necessary to locate the child, or grant any other relief. That's just catch-all language. And 9.7-109. So if the petition contains any allegation and the court finds that there is credible risk, the court may issue an ex parte warrant, meaning that both parties don't necessarily have to be there, for physical custody of the child. And then the respondent will be afforded an opportunity to be heard at the earliest time after that warrant is issued, but no later than the next business day, so that, because things are moving pretty quickly, and we have to, I think we had some other language like the next day or something like that, and we had to just kind of think that through, because we needed it to be very clear that this is something that is is an imminent problem. And then if they can't hold it, for some reason it's not possible, then they're gonna have to do it on the next business day. And then we go into what needs to be in that ex parte warrant. Again, a warrant without the both parties being knowing about it. So then we go into putting the child in an in a safe interim place while all of this is pending, if possible. And then this warrant could be used to search. It could also be used to search NICS system. It could be used or any other similar databases to locate or to find out if the respondent has a history of domestic violence, stalking, or child abuse or neglect. And the petition gets served, just talks in the service of the petition, and then how the warrant can be issued, and that if the court finds a less intrusive remedy will not be effective, then the law enforcement officers will can go into a private property and take physical custody of the child. And then they need exigent circumstances in some cases if they have to do forcible entry. You talk about best interest of the child. That's really what we're trying to get at here. And then we get to the award of attorney fees, costs, and expenses if necessary. And then we just get to the very end, which tells the title. If you go all the way down to 9.7-111, keep going on down. And there we go, that the title is called the Maryland Child Abduction Prevention Act. I mean, that's just technical language, that's all. So that is the book that we wrote, I mean, the bill that we wrote.
Are there any questions?
Freudian slip there, Delegate, Freudian slip.
Do we get a
So-
signed copy?
So Delegate Valentine has a question. Go ahead, Delegate.
On the last page, forcible entry of a residence?
Yes, did you see the exigent circumstances?
Yes, that's what I'm on now. I'm reading that now.
Exigent circumstances only.
Okay.
Like if the child's life is in danger or one of the parents' lives are in danger, but mostly it would be if the child's life is in danger, and it would follow the normal exigent circumstances that allow law enforcement to.
I was going to say that those are things that are in place now. So I was just curious as to why it was written.
No, we're just trying to, we're trying to do everything we can to put it as close by as possible so that the court would have it, and then the attorneys will have it. It's clearly laid out, and it allows, because as it stands now, like a no-knock warrant in Maryland, we have certain hours that we have to execute.
Mhm.
This would allow law enforcement to make that forcible entry at any hour if the court allows it.
So
I mean, and you can still not, quite frankly, but they can make that forcible entry.
So if a petition is filed, how quickly can the parent get before a judge?
I believe it has to be heard. Well, it depends on the circumstances.
Mm-hmm.
So you file your petition, and in some cases, it could be the next business day. Okay. In other cases, I think it would go through the system in the normal docket.
Okay. So it just depends on what is presented, to
Right.
show the urgency of the matter.
That's my belief.
Okay. Got it.
And if I'm wrong on that, I will let you know.
Okay. All right. Are there any other questions? I think Delegate Taylor wanted to, or had possibly a question now that we've gotten through it, if she's still there. I know she was trying to do a couple of meetings. There we go.
I'm still here. Okay. Listen, that was a yeoman's amount of work right there. So thank you, Delegate Bartlett and Council. I just wonder if right now we could just hear just sort of a synopsis of where we are now with this bill and how it compared to where we were. Just so I can hear all and how all the amendments affected the original language. In short.
Okay, well, I will do my best to make it short. I'll tell you honestly, sometimes this bill was originally presented, I believe, in 2020. And at that time, I don't know how many states had already adopted the Uniform Child Abduction Prevention Act. But since that time, we want to okay, we have a new sponsor 3 years later looking at the bill. So I put in the bill exactly the way it was written the first time around. However, in talking with practitioners and members from the family law section of the bar, some of those details were a little bit particular to certain circumstances, but not all circumstances. So what we tried to do is make this more inclusive and also more objective so that the court can have something to kind of hang, some clear language that is clearly defined and clearly accepted, and as well as the lawyers could have clear language, because the last thing you want to do in a child abduction proceeding is to have people trying to figure out, what do you mean by what you just said? It needs to be clear as possible. So what we did, Delegate Taylor, is strip the bill as much as we needed to and put in the uniform language that has been accepted by, I don't know how many states. It looks like I'm looking at maybe 13 states, or maybe I'm doing a quick look. Looks like 13 states, because it's been tried, it's been done, it's been proven to be effective. And so now Maryland can kind of get in and say, okay, this is something that we can do, and that we, that we know is, it works. So hopefully, Delegate Taylor, that answers your question.
So
Thank you,
I think
Delegate
I have a quick question for you, Delegate Bartlett. And I'm assuming that this bill was initiated because there's some concern with how the federal jurisdiction is able to handle cases in our state. Is that what kind of prompted this, or was there something else?
Well, the federal, it's more of, I don't know that the federal law is precise enough for the states to be able to do what they need to do. Constituents came in essentially because they were constituent parents who lived in Maryland, who have gone through the process by themselves, paid an enormous amount of money by themselves. And essentially what they're trying to do is go forward and not have other parents have to deal with some of the difficulties that they had, so that if Maryland if we could have that order here in Maryland courts issued by a Maryland judge, then perhaps that child would never even get out of the state to begin with, because what they're having to do is the child goes out of the state and then they're having to travel back and forth to the Czech Republic, or as one witness stated, and get the child back. And so that becomes an issue. The other thing is that it also would help with the risk factors, because some of these folks went over to another country thinking they were going on vacation, thinking that they were coming back. And these risk factors, these risk factors can actually be turned into, sort of like a guidance for parents to say, oh, wait a minute. And most of the parent constituents have said, in hindsight, looking back, yep. But, so in that regard, I think that's why we need it here in Maryland to help going forward.
Thank you very much. And Delegate Pastor?
Yeah, I just want to say that this piece with the risk factors, that is just so incredibly strong and great. I briefly worked, because I worked Middle Eastern terrorism primarily. There were times when a lot of the people were married to American citizens, and they would take the children to their home country. The other partner would take them. And then the parents went through it all. And just on a federal law enforcement level, it was just very difficult in terms of getting the children back. But these risk factors are so clear, so precise, so in your face. If we, way back then, were looking at that, and that was just a whole piece of the paradigm, that would have changed so much. That is so important to have it delineated like that. This is so, with the amendments, just so incredibly clear. Yeah, so thank you for the time and the work on it. It's just so clear now.
Thank you very much, Delegate Pastor. Delegate Kaufman,
I just want to move favorable.
do I have a second?
Second.
Second.
Okay. Okay, discussion. Yeah.
Delegate Valentine, maybe, I
Yeah.
think he has a question.
Yeah, exactly. So let's go ahead with Delegate Valentine.
It's a statement. Thank you, Madam Chair. It's a statement as well as a question. First of all, thanks, Delegate Bartlett, because obviously you've put a tremendous amount of work in this. That's obvious. But my question is, and it kind of goes back, I believe, somewhat to Delegate Taylor's question, where I'm kind of like where we started to where we got, and you've kind of given us the chronological order. I just want to make sure that I'm not missing anything in the mix or something that's not completely understood. So I think you've done a great job explaining it. My only concern is it seems like I don't know how far away from the beginning we are to where we are now. That's my concern, and not maybe I did miss something, but so that's not really a question, Madam Chair. I just kind of, there's several different versions that I've got in my folder here, and I'm concerned that I might be missing something. So I just want to bring that up.
Gotcha. So let's hold off on the motion for, I know the motion's in place, has been seconded. So we're really in discussion. So that's fine. Okay. So let's just keep the question going in discussion. So Delegate Bartlett, if you could, as Delegate Valentine mentioned, if you could just explain kind of what the original, I guess, again, and are we missing anything? Because I know we've taken out notice of intent to travel. I mean, that was a big piece that was taken out of the first part. So maybe explaining there, what the difference is, and excuse me, but that from the first version, we've now taken out notice of intent and why we took it out. And then maybe, again, I know the second version now has more of the uniform code in it. But if you can just maybe take a couple of minutes and just do that for us one more time. Thank you.
Sure, no problem. Let me tell you, I won't say I got beat up, but I'll say that the practitioners thought I was a little crazy to have notice of intent to travel in the bill to begin with. And the reason for that is because it was confusing. It's not the language that practitioners use in this type of circumstance, because one can relocate, one can travel. Every parent who travels is not necessarily an abductor.
Mm-hmm.
So they were stating, I'm looking at one of the petitioner's letters, and she was stating that the amended bill, we had in there travel whenever there was a reference to meaning relocation in existing Maryland law. Excuse me. And that it was confusing to put that in when we're talking about abduction prevention. The goal of this bill is to prevent a parent from abducting their child. It's not from necessarily ever being able to travel with your child. It's abduction. It's meaning to take them and keep them away from the other parent. So that's why we changed that language about abduction in general, and we said abduction is the wrongful taking and keeping of a child. And then we went to explain what was wrongful taking and what was wrongful keeping. So we just literally broke it down to more precise language, so that it wouldn't be some of the, for instance, I have a note here from a practitioner that a parent would not normally file a notice of intention to a court. Why would you do that? You're not going to do that on your own. You're not going to do that just because you have nothing else better to do. Now, if you've been ordered to, whenever you leave, you have to file a notice of intention, but it's not something that's generally done. So we wanted to make sure we're updating the law we're updating the bill to the circumstances, the narrow circumstances that we're trying to address, and that is abduction.
Mhm.
Hopefully that makes a little bit of sense.
That does.
Okay.
Thank you. That does. That change in terminology from travel to abduction does.
Yeah.
Okay, anything else regarding the current version other than it? I know it lines up with the Uniformed Child Abduction Act. Is there anything else that people may want to know about it? Anything else, Delegate Bartlett?
No, I just want to say thank you to you and for challenging me to get it right. And that's how I looked at it. I looked at it as a challenge to try to get it right. And the folks that I work with are absolutely incredible. The practitioners, everybody has been incredible. That's all I can say. Everybody's been really, really incredible. Uniform Law Commission. So this is not a work that was done all alone.
Right. Well, I mean, it's pretty comprehensive, so that's for sure. Delegate Valentine, did you have something else?
Yes. Thank you, Madam Chair. The last question I would have, and I'll be brief, is
It's
I
okay.
know initially the judiciary opposed all these different versions. Have they come on board now, or have you had any contact with them where they're now more okay with this?
I have not had communication with them. I have been talking to, it's been a second level of communication, meaning the Bar Association Family Law Section has been advising them on the changes that we're making. I have not gotten any type of formal nod from the judicial conference.
Okay.
Yeah, only the communication from the Bar Association Family Law Section.
I was just thinking, since we're kind of going through different versions, that other folks from the beginning would be up to speed with the versions as well. That's all.
So I have, just to let you know, folks who opposed, there was a practitioner, Melissa Kuzinski. I've been working with her. I've also been working with the Family Law Section, and to the point where they have been meeting, they have been talking about the bill, they have been giving me feedback, and I know that they have been talking to Judicial Conference. Judicial Conference did not say to me, we still hate the bill. They didn't say anything like that. So, nor did I hear anything from the Family Law Section of the Bar that Judicial Conference still didn't like the bill. I never heard anything like that. It seemed from the references that I got that this would be better than the other one. But I'll tell you, in transparency, Delegate Valentine, there is a lot that we're telling the court to do.
Correct.
And as you can see, the Judicial Conference sometimes don't like when we tell them what to do.
Yes.
So that I couldn't get around, even if I didn't amend even if I amended it, differently. I can't get around, the fact that we are telling them the factors to consider, because we do say, you will, review these factors. But we also say, and anything else the court wants to do. I mean, there's a lot of that. There's a lot of that type of language, and anything else the court wants to do, or anything else the court seems fit. And that type of thing is like a catch-all, so that if the court sees something that that we haven't listed here, that they can still take into determination. We also have that the court on its own motion can, can review the factors or can review, anything that we've listed here.
And do you know what the posture is on the cross file right now?
We are the lead. The cross file is not moving yet, mostly because they're waiting to see what the House is going to do. And the cross file might not move, given that this is, crossover week. It may not move, but we have been the lead on this bill.
Okay, great. All right, so we had our motion, we have a second, and I don't see, is there any other discussion on the bill? Any discussion on the amendments at all? Okay, all right, because the first thing we have to move are actually the amendments, okay? So what I want to do is go back and let's do that first. So is there a motion on the amendments?
So move. Motion
Okay,
to
all
move
right,
favorable.
thank you. And is there a second on the amendments? There are amendments 1 through 4. I'm sorry, did I hear a second on the amendments?
Second.
Yes, second.
Okay.
On amendments 1 through 4.
Okay. All right, everybody understands the amendments. I don't have to go back through them, right? They're pretty comprehensive. We spent a lot of time on them. Okay, so I think all I need is a hand motion or reaction to the amendments. Everybody in favor of the amendments, if they'll raise their hands. Okay. All right, I think that is everybody. Okay, anybody decline the amendments? Okay, I think we have everybody on board. Delegate Tomlinson, I wasn't quite sure. Did I see a hand go up for you? Okay, thank you. All right, great. All right, so now let's move on the bill. All right, do we have a motion to move on the bill with the amendments?
So move.
All right, and a second?
Second.
Okay. All right, we're gonna do a roll call vote on this one, okay? Starting with Delegate Bartlett.
Aye.
Okay, Delegate Kaufman, my apologies, Delegate Boucher,
Yes.
Delegate Kaufman,
Aye.
Delegate Pastor,
Aye.
Delegate Simpson,
Aye.
Delegate Taylor. She's still,
Aye.
okay. Delegate Tomlinson,
Aye.
Delegate Valentine,
Aye.
okay, and I'm an aye, and Delegate Simmons, of course, is excused. Great, so we got a bill out. Let's see if we have a few minutes to go over HB 1020. Do we have in the room, if you can bring in anybody from DHS who may be here, Jeremiah, and also Delegate McComas if she's in the room, in the waiting area. And Lauren, do you feel comfortable going over the amendments to this?
Sure. My understanding and reading of them, I don't know if there are further amendments, but at this point, they're technical and they restore a provision of current law relating to the relevance of a disability in these proceedings. And then I would just need to make one additional technical amendment to those amendments just to correct an erroneous cross-reference that was due to the renumbering caused by that amendment.
Oh, okay. Okay. All right. And I asked Katie Peterson from DHS to join us. And Ms. Hartich, where are you from?
Hartich. I am an assistant attorney general assigned to the Department of Human Services.
Okay, great. And I just, go ahead.
I've worked in child welfare for 35 years in terms of children who are in foster care and children in need of assistance and termination of parental rights.
Okay. All right. And I asked them to join us because of that very section 9-101, because I believe, 104. I believe there was an issue with that or a concern that had been voiced by DHS. And I just wanted to find out if you all are now okay with the bill based on the amendments that have been now added.
Katie, did you want me to speak?
Yeah, you can go ahead.
Okay.
Yeah, she says yes.
So I still have a major concern with how you define parent. Because you've excluded some people who are legal parents, and you've created rights for de facto parents that they don't have. And you have given biological parents rights they may not have. So for instance, if we've terminated parental rights of a biological parent, then they are not on an equal par with an adoptive parent. So by defining parent as biological, adoptive, or de facto as in a statute, you've created a very strange class. You're not addressing who's the legal parent. You're also eliminating the same-sex couples who you can have two mothers. Like the birth certificate could contain, it doesn't say mother and father anymore, it says mother, mother. That person, one of those is not going to be biological, and one of them, they're not going to be adoptive. They would be a parent, a legal parent, based on being on the birth certificate. By saying biological, you then include people who would have no or may have given up their parental rights, such as a sperm donor or a surrogate parent. They should have no legal rights and the same rights. By leaving them in there, if they're biological, they still have their rights, even if they've terminated parental rights in a termination of parental rights proceeding, or if the adoptive parents are the parents. So if they've even consented to the termination or to the adoption, then by including them still as biological, you're still giving them rights. Even though the courts have recognized de facto parents as not having to jump through the hoop of proving unfitness or exceptional circumstances, the courts have not gone beyond that to equate them with a parent with fundamental rights. And just look at the most recent case coming out of the Supreme Court, where a step parent was charged as having sexually abused a child, and the court said, no, it's a parent. It's meant to be a parent. It's not someone who's potentially a de facto parent. So de facto parents, like the courts have not gone that far in de facto parents to say, for instance, let's say there's a medical major decision that has to be made about child. The way this statute is drafted, you would allow a de facto parent to have a say in that. And, you're giving them fundamental rights that I'm not certain that, that's your intent, is that a de facto parent should be able to make long-term decisions about a child's life, a child's medical care, treatment, any of those things. Is the de facto parenthood in Maryland really one that means that you don't have to jump through the hoop of proving unfitness or proving exceptional circumstance in order to seek custody or in order to get visitation rights? So by lumping them in with people who have legal parental rights, then you are giving them more than they had. And I don't know if that was your intention. There's also a problem in terms of our laws don't give all biological parents rights. For instance, if a woman is married to a man at the time of conception or birth, that person is considered the father of that person. And in order to undo that presumption, there are various procedures that have to take place. This would eliminate that whole concept that's, you know, historic within within the laws. You know, it would undermine that need where a court makes a decision of whether it's in that child's best interest. The same thing happens when you have someone sign an affidavit of parentage. They're a parent, whether, you know, the biological parent can come in and challenge and undo that. You know, we have a number of procedures and case law set up in place that this just completely upends.
So let me ask you this, given the statements you've made about your concerns about de facto parenting and additional rights that you believe that the biological parents may have that are different, would you be willing to maybe draft some language that could be a possible amendment to this bill to address those issues? That would be very helpful to this subcommittee. Also, again, I want to just make sure I heard that originally the bill eliminated 9-107, and that's now been put back in place. And are you okay? Is DHS okay with that?
Well,
now,
I believe
after
9107 should never have been eliminated.
Right, so now it's put back in. You're
Right.
correct. I believe that was somehow I was told folks don't know how come it was removed originally, but it has been put back in, okay? So that's now been put back in. But you've raised some other issues that you had concerns with. And I just want to find out if there's some language that you feel could be added to this bill to now make it a bill that would be substantially equitable for all the rights that you've mentioned.
I really feel it should be legal parent. I mean,
Okay, so I'm saying, are you guys willing to offer an amendment to that? To explain or to put in the various places what we need to do. So you're saying that you don't feel comfortable. Well, okay.
with the definition of parent.
Okay, right. Okay, so maybe we can work on a definition to amend it in some way. Okay.
So let me look at your 9. So what?
So have you seen the amendments? I guess maybe that's the question first.
I believe that
Yes, Janet, so those are the ones I sent over this morning.
right, and I'm not seeing the issue and concern in 9101 is that there are more people who could potentially abuse or neglect a child than simply a parent, a legal parent, somebody defined as a parent. And 9101 protects the child for as it's written now, as it exists now. It protects a child who's been abused or neglected, or someone who's abused or neglected them. So, for instance, let's say—
I totally get that part. So let me do this. Let me ask Ms. Lenning if you would just make a comment to this. Thank you so much for joining us.
Okay.
Sorry, I'm trying to read two things at once. So I'm sorry. So Janet, are you saying you don't like the definition of parent in 9101?
Well, 9101 doesn't define, I'm sorry, the current, I guess 9101 does define parent.
Yes.
I'm talking about the old 9101.
Okay, well, the old 9101 doesn't change at all.
Well, it does though.
Wait, I'm sorry, except for it changes custody and visitation to parent to time, the legal decision making and parenting time. Everything else about the old 9101 stays the same. I know this is an area I work in a lot because I'm at the House of Ruth. So
I understand that, but think about it this way. So we have said parenting time, and we define parenting time as time in a parent's care. But under our current 9101, it applies to people who are not parents under any definition and who would not have parenting time. So for instance, in a case where I have had a grandparent who is the custodian of the child abuse that child, 9101 applies. Under this parenting.
Can I just ask you a question? So what it says is a parting to the proceeding. So this is like a custody proceeding that we're talking about. So are you saying it'll be if the grandparent had custody of the child?
So, but my problem comes in when you change it to parenting time, and then you define parenting time as time by a parent, and that person is not a parent. So we could
So
have,
I'm gonna stop you right here, because I think that we're getting into probably some details that we need to probably work offline, and bring back to the committee. So I appreciate everybody being here, and let's just, we'll work together, and I'll facilitate us working together to try to come to some kind of common ground on this. But what I'd like to do is go ahead and, release, I think, the committee now, because we've now gone over an hour, and I don't want to keep people longer than that. So I'm going to ask for a motion to adjourn, and I'm going to then recontact both of you and other stakeholders to just find out, is there a way for us to resolve this issue and concern that you guys have? Okay.
Thank you,
All
Delegate.
right. Thank you
Thank you.
very much. And do I have a motion to adjourn?
Don't move.
All right. Thank you, folks. And we will see you later on this evening.